Everybody, this is Jay Wood.
Yeah.
He's the representative tonight for family law. If you have any questions, he's going to do a short presentation, and then after that, he's going to have Q&As, and we should probably be wrapped up by 6:30. Okay. Thank you.
Thank you. Yeah, probably even before that too, just full disclosure. But to start with, I am nowhere near an expert in family law, but I am doing this because I appreciate so much what the Whitewater Valley Pro Bono does for the community, not just in family law and all the different topics that they have the flyers over there for. So my thanks definitely goes out to the people in charge of this. So thank you guys for that. I am talking about family law though, because this is one of my main practice areas that I do. I'm a partner at the law firm across the street called BBFCS. We've been called everything in the world from BBKCC, BBKFC, BBABC, you name it. So that's who we are right now, is BBFCS though. I'm a litigation attorney, and that is what the family law section really turns into. In Indiana, family law really comes down to anything that has to do with what we would consider domestic relations. So that could be a married couple of a male and a female, or the same gender as well. It could be a married couple that has children, do not have children, or a couple that aren't even married and just have a child in common. And then I've seen a whole host of other types of situations as well. So there's really no cookie cutter way to say this is definitely a family law case, or this is a protection order case, or anything like that. So if you have any questions, if your situation specifically might fall into that category, just ask it, and we'll say it probably touches on family law as well as something else, which is one of the cool things about law, is that it really does, it touches on many different things. To start with, a lot of I would say the lion's share, 90% of the types of cases that we see as family law attorneys are divorces or matters involving children. So I'll kind of break them apart into those two, if that works for you guys that are here. So to start with, on divorces, in Indiana, there's not a whole lot of requirements to get a divorce. The one that should be the most obvious, though, is you have to be married to get divorced. So it has to be a legal, lawful marriage. It doesn't matter if it's in another state or not. It doesn't matter to who you're married to, as long as it's somebody that's of age, which is 17 or above here in Indiana. It just has to be a lawful marriage to get the divorce. Within the time period of the marriage is what is really looked at in the remaining requirements to get a divorce in Indiana. So those requirements are set out by statute, that you have to be an Indiana resident. So that's why it doesn't really matter. For instance, I was married in Florida, but I've lived in Indiana for 6 years now, I believe it is. So so if I was to get divorced, it would have to be an Indiana divorce at this point now. It doesn't matter if you have children or not to get the divorce, but if you do, you would have a different type of divorce case. And that would be a different form to fill out whenever you initiate the matter. There's also the issues that a judge has jurisdiction over to decide, such as what assets that the parties have. So even if husband has a job and he has, let's say, retirement accounts or investment accounts, or some type of deferred compensation accounts or anything like that, wife is still entitled to that as an equitable share, not equal. Equitable does not mean equal. It's not 50-50, here's where I split the baby in half sort of thing. It's equitable, what that person can argue for and attain from a judge. Or same thing goes with debts, though, which is actually much more common, because you're going to see there's a mortgage. It's a $200,000 house that has $175,000 left on the mortgage, and then how the judges decide how to divvy that up. Other debts that you typically see are the car loans, credit card loan, medical bills, everything that we're all burdened with that we have to see every day. Other than assets and debts, without children, there aren't a whole lot of issues that a judge will have jurisdiction over, or frankly even care to hear about unless there's some matters of personal safety to either one of the parties, um, or if there's some type of issue of encumbering the other person or hampering and and basically doing what's called a trespass on the property of the other person. So if somebody's burning paperwork out of the filing cabinet to hide assets and stuff like that, the judge is going to want to know that and take action on that, because that's not just an offense to the other party, that's an offense to the whole judicial process itself. So luckily, we in Wayne County especially are very blessed to have judges that care about those sorts of things. When you start involving children into any type of matter, it of course gets more complicated from a legal sense. It's obviously a blessing from God to have children. I have myself, so I'm going to acknowledge that first. But it does complicate matters because parents have rights, even bad parents have rights. The children have rights as well, and we all have our own perspectives of how we approach any type of matter. So although everybody in one party, let's say the mom's life, everybody in the mother of the children's life is going to tell her what a great mom she is, how well she takes care of the children, how the children only respond to her, and they're only good at school the next morning when they spend the night with mom, how mom keeps them hygienically clean, safe, cares for them, just loves them, the children love them back, all of that. Even if that's what everybody in mom's life is saying, that's not objective. That's not reality of what a judge is going to see. So father is going to have, and I'm not just thinking of any specific instance or whatnot, but father is going to have people that tell him maybe the same things, or maybe that mom's overhyping how everybody loves the relationship that the dream ideal relationship that mom has with the children. So just because the children are involved complicates the legal process of it just a little bit. Obviously, though, in the long run, it's to the benefit of the child. And when a child is involved in any type of family law legal situation, the main overriding issue that not only the party should consider and not only the lawyer should consider, but that the judge has to consider as well, is what's in the best interest of the child or a best interest of the children, however it should be in that case. And thankfully, there are, in our court systems in Indiana, there are a couple of different approaches to take to that, where the judge can hear evidence from what's called lay witnesses, which would be people that aren't experts in any field. They're not child psychologists or anything else like that, or medical professionals or anything, but instead they're the mom, the aunts, the neighbors, the teachers, those people that get to observe the child and say, yeah, I've known this kid for 5 years. The divorce started happening a year ago. So for the last, for 4 years before that, the child was fine. Every day came in ready for school, clean hair, just a happy child. But then this last year that everything's been pending, we've been having behavioral issues, or the child is tired and sleepy during class, that sort of thing. Or if that's not, if there's a more serious issue, if there's an abuse, if there's a neglect that's being involved, or just really anything that puts the hair up on the back of your neck, you could always request that a guardian ad litem be appointed by the judge. That's an area that I'm not an expert on. We actually have guardian ad litems that help out the pro bono organization here quite a bit. And unfortunately, one of them couldn't be here today. She could speak volumes above anything that I have any authority on talking on. But I will tell you, it's a double-edged sword from my experience, because they are no nonsense. They don't care what mom wants. They don't care what dad wants. And in reality, we don't want them to care. They're there to tell you what's in the best interest of that child. And it's that hard truth. It's that truth that is a brick wall, and that's where the truth is. And they get to tell the judge what their investigation into the matter has found. So with a guardian ad litem, a GAL, what they're able to do is look at medical records, school records, interview the child, interview the parents, require the parents to go get hair follicle tests for drugs, for instance, or any other issue like that. They can verify employment, they can verify living conditions. Tons of power. It's the power of the state of Indiana. It's a good thing to have, but that's a lot of power. That's if you open that Pandora's box, you did it, and here it is. So careful what you wish for, sort of thing. But if it's necessary, they will see that. A lot of people, at least a lot of parties that I see in divorces, so say I'm representing the wife in a divorce or the mother in a divorce, and I see them requesting the guardian ad litem, I will definitely make sure our ducks are in a row first before we go there with that. Luckily, in Wayne County, although we don't have a lot of them, I think we only have 2 that do the types of family law cases that we're talking about today. They're professionals. Overworked. They're the classic, you need these people, but they have so many cases that's in front of them that they've got the experience, out of this world type of experience, but you really want to make sure that you don't pigeonhole them into just certain types of cases. With family law, it really doesn't stop at the divorce either, or at the paternity, the determination of paternity. It kind of really continues on, and it continues on, and it continues on until the child is in college, or at least is 18, or if they have special needs, much longer beyond that as well. And those are issues that really make it hard to give a presentation like this without knowing any specific situations. So I'm really glad that we do have the question and answer section that comes after this, because right now it's just the boring part. It doesn't, it either applies or it doesn't, sort of issue here. And I'm good at the boring part because I talk to juries, every couple months. So I'm good that I have a captive audience, and I'm happy with that. But if it doesn't apply, I totally understand it. Feel free to just disregard, just say, yeah, this guy's droning on again. Like I said, I have kids, so I understand. Another thing to consider when it comes to family law is kind of the opposite of dealing with children and then adults who are married. I should say the opposite, but it's on the other end of the spectrum of that. It's where people become incapacitated due to their age or due to some type of medical conditions, and they might need what's called a guardianship over them. And a lot of times a family member will be appointed for that if there's not somebody available. And I'm only going to touch on this briefly. But if there's not a family member who can care for that person that's incapacitated due to a type of dementia or a type of degenerative diseases that are affecting their abilities to care for themselves, make decisions for themselves, then the judge can appoint somebody. To kind of give another plug to the pamphlets that we have over there for estates, when you're setting them up, when you set up your power of attorney, I do this in every power of attorney I do, is I put the very last section is section 9 of the ones I create. It states who you want to be appointed guardian of you. If you're in a bad car accident in January, you slide off and you're not able to make decisions for yourself while you're rehabbing and whatnot. If somebody needs to decide, who's going to pay the bills, who's going to have access to my bank account, or whatever the case is, that's who that guardian is. So that probably doesn't apply to the group that's here today, but oh, it does. Okay.
We're to chair the theory because she's going to go to law school, but
Oh, nice. Good.
when you said that, I was like, because my husband had a stroke.
Oh, yeah.
Ago, and he's in the nursing home.
Right.
And actually, I am his POA. So
Oh, perfect.
like
So,
that, we have on health and financial.
okay.
And I want to add her to it. So when you were talking.
So his paperwork said that did a judge adjudicate you and order you to be the guardian over him already?
Yes.
Okay. So yeah. So but not just notarized on the paper. Gotcha. Cool. Okay, then yeah, that's yeah, and that's a reasonable thing as well. So That's good. We'll touch on that definitely in the question and answer part. So yeah, I'm glad that he had that set up because that's, oh no. Yeah. It takes longer. It's more stressful for the client, I find, when that's the case. So, but it's not impossible as you've seen, but I'm sure it's been frustrating. Yeah, yeah, absolutely. So that's pretty much the nutshell of what family law is in Indiana. It really covers anything that has to do with a domestic relationship, even if it's just a one encounter where a child is born, or if it's from a family that's been a husband and wife that have been married for 50 years. So with that being the case, on time, do I have like another 20 minutes or so? Is that turning? Okay, so 20 minutes is plenty of time for questions, I hope, so we can get that going. I don't know, ma'am, if you wanted to go first. I know your child's being good right now, so my experience is they're not good forever. So. Like,
Are you asking?
yes, please, yeah.
Greatest, I heard that. I haven't thought.
It's okay. Yeah.
Oh. That if I'm not married, that I automatically have full custody of my daughter. Is that the case? And is that the case if the father's on the birth certificate?
Okay. Good question, and I really appreciate you making that specific statement at the end there that the father's on the birth certificate. So there's mothers, maternal, really easy to find out who the mother is of a child because where the baby comes from, right? So it's very easy to tell that. With fathers, you have to establish paternity. One of the ways that you can do that is a blood test. The parties can agree, and if the father, and that's by filing affidavits of saying of paternity there. And another way is if it's on the birth certificate, there's a presumption right there that you've already acquiesced that that's going to be the father of the child. Fathers, they have rights too. A lot of times what you'll see is they're not as involved as society would expect them to, as decency would say that they should be, but they still have parental rights, which also means they have obligations too. So, for instance, a lot of times what I'll see is in a situation where I hear like those keywords or those buzzwords that you're kind of saying right there. I'll think that the person's not stepping up. That I'd be worried that what's called the 4D court in Indiana. 4D is a prosecute. It's like an arm of the prosecutor that gets to speak for the state of Indiana and say, hey, the state of Indiana is, we have expenses here. We have insurance that we may be providing to the child, which is a lot of times what you'll see will initiate one of those types of cases. So they'll want what's called a child support obligation worksheet, the CSOW, child support obligation worksheet. They'll want that filled out, determine what that father should be compensating you with. And then once the father starts to see, well, I already have to pay $50 a week, whatever the case is, $7 a week. I've seen that's the lowest I've seen that they've actually ordered $7 a week. And I was like, I love my kids way more than $7 a week. So I would hope that the guy would step up, but we'll see in that one. That one's relatively fresh. The child support obligation worksheet sets out the obligation part of it, which might trigger in the father's mind, if I have obligations, I also have rights. Those rights entitle me to parental access. We don't call it what is it? There's kind of an antiquated term. I'm trying to think of what it's like. Parent, it's basically parenting time is what the father. Yeah. Well, it's the Indiana Parent Time Guidelines. But what you used to call it, not visitation. Thank you. Yeah, you don't visit your kids. You don't. Nobody's ever been like, oh, it's been great. I just visit my kids for the last 18 years. No, you raise your kids. Yeah, it's not visitation anymore. It's access now because you're a custodial parent, which in this type of situation that you're saying, I would consider the mother to be the custodial parent, and then the father would be non-custodial. So if you go to the indianain.gov website, Or if you just go to Google and type in IPTG, Indiana Parenting Time Guidelines, it'll tell you exactly what those situations deal with, because a child's life isn't just when they're real little and then they go to school and then they graduate. The Indiana Parenting Time Guidelines go from 0 to 3, 3 to 5, and then onward from there all the way to adolescence. And they cover different common occurrences that happen. And another common one too is there will be distance as a factor that comes into this. So say like one parent lives in Wayne County, Indiana, another one lives in Carmel, Indiana, so now distance is kind of a factor. Or another parent's in the military and they're in North Carolina, hopefully, or overseas, or another parent's in New York or wherever else you're going to see it at. A lot of times, actually, Chicago, I'm seeing quite a bit of right now. So with that being the case, the guidelines really set forth what the minimal expectations that a judge would have for a case like that. It's probably best just to talk to somebody that's been in a similar situation before. That's probably the best on that. So your question is not really how to establish who the father is, right? It's basically what obligations and what rights the person has. Yeah. So the obligations are to, within their means, provide support for the child. And when support is provided, that's for the real bare basic necessities: haircuts, school supplies, food, clothing, those sorts of things. That's what that's for. But kids like soccer or football or whatever, softball, they're going to need extracurricular type of stuff as well. She's getting in there. So she's yeah. Okay, good deal. Yeah. So there's so when the kids need those sorts of things, the parents should work together. There's really no way of obligating a parent, though, or a father to step up without a judge saying so. When the judge says so, it has the force and effect of the state of Indiana. People with badges on their chest, guns and handcuffs on their belts are the ones that go and enforce those. So if somebody doesn't do what you want them to do, they're just a jerk. But if somebody doesn't do what a judge says to do, they're now a criminal because they're in contempt of court. And eventually down the road, and it's a long process, it's not immediate overnight. Thanos doesn't snap his fingers and the guy goes and gets arrested. The judge will hold the person in contempt, or has the option, I should say, to hold the person in contempt and then send the police out to have him come and answer to the judge why he should be thrown in jail, why he shouldn't have to step up when society requires him to. It only works with both parents in there. Yeah. Mm-hmm.
So what are my rights to like prevent him from like picking her up from daycare without my consent or being like have the right to unsupervised time with her and before any court's involved?
So two things there to start with. To keep him out of your child's life would be alienating him. And we can't do that without a justifiable reason to do so. And something like that probably would require the appointment of a guardian ad litem to investigate and say the lifestyle this person leads is dangerous to the child. No judge, no human, I should say, even wants to go to bed at night thinking a child died tonight because I let them go spend a day at a fentanyl dealer's house. You know what I mean? That's obviously the extreme end of it, but that's what we do in law school. We look at the whole spectrum of everything that we can. On the other flip side coin of it, though, if it's just a parental philosophy, like you say no candy after 6 p.m. and he's like, no, it's popcorn and candy and movie time. Oh, okay, yeah. So the easy way out though is get him sugar high and then go to sleep. so it's usually not that, but yeah. If there's a danger to the child and it becomes an issue, you can only go so far to protect yourself or your child. I I used the terms protection order earlier, and that's kind of like adjacent to family law, if you will. But a protection order is something that protects intimate partners or people that share familial types of relationships, such as parents of a child. And they protect either the other partner from stalking, harassment, threats of violence, past violence, or sexual abuse. They protect the partner of that. Or they can protect the child of the same stuff. Just in Indiana, we call it by next friend. So it's kind of like a step down of it, if you will, but it keeps that person away from the child on that cases. Protection orders are just a piece of paper, though. It's not a bulletproof vest. It's not. I would 2 weeks ago I would say it's not Secret Service protection. So, but now I don't know how far that goes either. But you catch my drift. It's just that. So I'm sorry, that was the first part on it. What was the second part of it too?
Right.
To keep supervised visitation or unsupervised?
Well, to prevent supervised, like, what rights do you have? It's gonna take her from my house. If she were dead.
Is there any kind of court order in place right now? Yeah, then you both have full, equal, joint, legal and physical custody. There's nothing to prevent that. You will want process in place that shows that what each of you are entitled to. And that would include that parental access that we were talking about. There's, you name it, it could be week on, week off. So everybody knows the first week of every month is mine, second week is his, that sort of thing. Or it could be every Monday and Tuesday is me, Wednesday is him, Thursday and Friday is me, and every other weekend. It could be in any variation of any of that stuff. But if it's not in a paper order, when you call law enforcement to come and protect you guys, the law enforcement is going to say, why shouldn't a father be able to go take his kid? He says he's going to take her to dinner. And then obviously that might not be what it is. You're going to have a different story. Whereas law enforcement is supposed to fall down on there, they have no guidance without a judge telling them what those rules are and those expectations are. Yeah.
You said that you didn't say that.
Right.
So if Mary didn't sign that paternity affidavit, doesn't that negate that child needing to do with that?
Not necessarily. What it does is it starts it's called a JP case, a juvenile paternity case, and it starts out in that 4D arm that I was talking about. You get it removed then to one of the superior courts or the circuit court. But he's still going to have rights. It's a police officer's not going to interfere in that and stop and say, I'm the dad. Look, there's a document with a seal on it from the state of Indiana that says I'm the dad. Why does she get to stop this? Because her name's on it too. And who knows what, depending on which officer you get too, it might as well. You don't want that uncertainty when it comes to these sort of things. You want it in place for that. Yeah. Does that make sense as well? Yeah. It's one of those, there's a best practice and then there's a reality. So, and who knows if you get like RPD, I think has around 72, 77 officers, something like that. That's 77 different personalities that are going to come that have been trained differently at the same ILEA, but they're going to be trained a little bit differently to respond to each incident. And so like for my father was a police officer, he would tell me stories about stepping into these and how much he hated it. And if I guarantee they were waiting for a call to come on the radio, they could just get out of there and go do something else because they hate these types of domestic situations because it could go from anywhere from being just a minor squabble over dad forgot to bring the bat bag to softball practice to they're literally about to murder each other or suicide murder each other at this. And it really exists and it's really out there and it unfortunately really happens. So the police don't want to deal with that if they don't have to. Family law is more of a civil issue, but you'd be surprised how much, I think I said earlier, law touches on itself in so many different ways. It's cool that way because you can go to law school thinking, I want to go write contracts for my favorite athlete, Michael Jordan, or Caitlin Clark, or whoever. I want to go write a contract for that person. And then you end up like I am giving giving his speech on family law, because that's the law school I went to specialized in sports management like that. So yeah. What else? So let's dig deeper here. I like the tea. That's why I do this. Okay. Mm, right on. Yeah.
A lot of, I've kind of really been like putting off doing anything legal because he doesn't have so much of like a record as much as, I know this might sound so pitiful, but like as much as I have a screenshots of him contacting certain people discussing very illegal things, and I feel like that may be something that
Possibly so. Even without an attorney, I should say, you can go forward and start the process and ask the court for help, and the judge can appoint that guardian ad litem we were talking about. But because we're only dealing with what's in your child's best interest, that's what the focus is going to be on. If it's stuff from 2021 that's illegal but kind of common, marijuana or something like that, it's probably not going to be a big deal. But if it's anything that would put your child at risk, that's not going to be on the judge's conscience. Yes.
he always, he wouldn't.
Oh no, but the evidence you have, you could present that. Yeah, that's we call an exhibit. It's evidence. So anything that you say is evidence, is testimony. Anything that you produce is evidence. It's an exhibit. Even if it's a video of him doing something, a screenshot, which is really good. I've got a case. It's actually in Henry County tomorrow that I'm going to. It's going to be about a 2-hour, 3-hour hearing. It's on both protection order and a contempt in a family law case. And we've got maps that we're using, audio recordings from the phone from interactions. We've got written statements from a coach that was involved in that. It's just one of those things where there's nothing more sacred than that family bond. And when the two should be adults in the room aren't getting along, if the judge won't hear from them and won't hear from the lawyers, he's going to hear from his appointed guardian ad litem, who's under his authority, under his control or her control. How old is she? 2. Nice. Yeah. It's fun age, yeah. Yeah. Best time I've ever seen in the library. So yeah.
Is that something that could go like to the end without an attorney, or probably?
You have the right to, and you could do it, but there's going to be legwork, and you're going to want to make phone calls and stuff like that as well. If he gets an attorney, you would be at a disadvantage to not have one, but it's not a requirement set in stone sort of thing as well. Not a lot of attorneys do this type of law specifically either. I think in the Wayne County bar, meaning like all the attorneys that work in Wayne County, there's, let's just call it, I'm probably off on the number, 40 of us. Out of that, probably 10 of us do family law. So it's called a quarter of attorneys that do that. And if you called me right now wanting me to do something, it would be the end of August before I could even have a consultation with you over this. That's how many of these situations there are, and how busy and backed up the attorneys are as well. It's just unfortunate reality of where we're at. So maybe getting it started and then contacting attorneys. And that's why I said that you could get it started yourself. And then get an attorney on board from there. Yeah. So. Mhm. Oh yeah, that's a good point, because she's got it. Is the kiosk at the courthouse? Does it have it for family law? Yeah, they have it now. Yeah. So it's good stuff to have. So, yeah.
Did you say there was less than 40 in the state of Indiana?
No, in Wayne County. I'm sorry. In Wayne County. Yeah. You could always go to like Indianapolis and hire an attorney, but then you're paying more. And not only like they're per hour, they're paying more. I think right now the going rate is around $350 for a Wayne County per hour. for a Wayne County attorney to do it. You go to Indianapolis, it's around 510, 520. And then not only that, for if they have to travel here, that you're paying for an hour of them in traffic, listening to their favorite podcast to get here. So that's a rough $1,000 to spend, you know. So it's not prohibitive, but it is what it is. So yeah. Greenfield, we see a lot from Greenfield too, though. So yeah. So that's all you got? No hard ones? That's all good. That's all good. Uh-huh.
She didn't want him to come up from daycare. Couldn't she just tell the daycare that
No.
this is who I don't want to pick for us?
Yeah, no, you couldn't say that. He's the father. So the mom can't alienate the father without a court order to say so to do that. In Indiana as well, when it comes to education, there's a specific statute on hand. I know it's in chapter 31. I can't string cite it to you right now, but it specifically calls for that both parents, both interested parties to the child's education are entitled to it. So the school would be committing a crime by not providing information and access to that child. So yeah, you run into that, and that's a problem. I don't know if it applies to daycare or not. I will say that, but I know it definitely applies to school, to education. Yeah.
And, because they missed an appointment. Okay, I'm a patient advocate. So I
Okay.
do all kinds of things.
Yeah.
So I called and the mother didn't answer. So I called the father because he was on the emergency contact list, but the children did not live with him.
Mhm.
So I did not realize that. When I spoke with him, he said, well, I have the children now because she's in rehab.
Mhm.
But I don't know if he's got custody of them because they were with the mother to begin with, but
Yeah.
he rescheduled the appointment and stuff like that.
Good.
So I was just like,
Yeah.
Even
Mhm.
though he has the children, we don't know the situation.
Right. And you're not obligated to know that. Yeah. There's no reason for you to have to look into every court case and every patient and say, are they the subject of some order that I can't find because it's under the parent's name, not the child or whatever. You're not obligated to that. Or even a lot of times it's a stepdad or somebody that's the other party. So it'd be impossible. That burden's not on you. Um, there's a difference between legal custody. I should say there's a different one, sorry. Bifurcate what people think of legal custody. A lot of times it's really who has physical custody and then who has the actual decision making when it comes to child. The decision making is what we do call the legal custody in Indiana, and that's where they're educated at, what religion they practice, what healthcare matters that they have, that sort of thing. If the order says that the parents have joint legal, one can't just make the decision. I hate this doctor now, so we're going to a different doctor. They have to agree or get an order from the judge that says, okay, no longer joint. Now it's sole for this one party. You don't see that a lot. Judges don't want to make these decisions. They get it that adults can be hateful. Adults go to war. So that just a husband and a wife or just a father and a mother can hate each other as well and butt heads all they want. But at the end of the day, the best person to make a decision for any child is going to be that child's parents, hopefully. And when it's not, that's when the lawyers get involved. But hopefully that's the case. So yeah. Oh yeah. Yeah. But that's the best father that kid has, though. That's the person that kid. I've pro temmed, which means I've sat in as the judge at times when like a judge is doing something. Well, I think the latest time when that judge had to go get a car, so I was pro temping for him on that time, and I listened to the parties just like a judge would. I'm sitting up there on the bench, and I'm realizing, I forget which judge said it to me one time, but the judge said, "I've heard you guys out. I've heard everything you have to say. I've seen every exhibit that you presented in front of me. And I can tell you, I'm going to make a decision that nobody here likes, and it's not going to be as good for that child as the child is." So the judge got off the bench, came back in about 10 minutes because we told the judge we'd reached a decision because the judge is right. That's not somebody that's touched by God that has a crystal ball that can tell you what's in the best interest of the child in the future. It's the parents that need to care, that should care, that will care. And if it takes a stern finger wagged at them, then that's what it takes. Yeah. Yeah, definitely. It's an impossible job that you have as well. So thank you for what you do. Yeah. Questions or did I bore everybody already? She's been a good baby. Yeah.
So in that case of like putting her as like her dad's.
Yes.
POA and stuff like that,
Right.
I will have to have those written all over again, right? To put her on there.
So I don't know the degree of disability that your husband faced with his stroke or not. But there's probably an incapacitation there to a level.
He's himself. I mean, he
Mhm.
doesn't remember things like he used to. Well, let's say he didn't remember things back then or before the stroke. So
Sure, sure.
He's more or less, he's still normal, but he does forget things or.
Yeah. What your
Okay.
best bet is, because somebody could always challenge that down the road, which you're, well, there you go. So there's always going to be, there's a yin and a yang everywhere. So yeah, that means you're doing something right.
Show me information on this, and she's on that paper too. I
Yeah.
told her, just so she felt that,
Right.
you know?
Yeah. But so if you don't want it challenged, just get a doctor to give an opinion that as of July 25th, 2024 at 5 p.m., I feel like he's competent to make these type of decisions that were presented to him. And that can be a one sentence, one paragraph, whatever it would be, just a real short letter like that. And then he could sign that POA. However, at this point, a judge is kind of in control of the guardianship. So you would want to file into the court and say, the judge thinks that he's competent, makes this decision, and he signed a document saying that he also wants Cheyenne to be a co-guardian or a subsequent guardian or however it's going to be structured on that. Yeah. Yeah. Because it's the judge is the one that makes the guardianship. The POA just says this is who I would wish to be. While I am a full capable means right now, this is who I wish to be my guardian. But the judge is the one that says this is the guardian. Yeah. Right. Yeah, good. Yeah. And our judges here are really good about the guardians. They kick stuff back to me that I've written. And they're like, hey, just so you know, there's a little bit of statutory language that needs to be in there. And I appreciate it. I'm not even offended or anything because I want to do a good job. But if I didn't cross every T, let's get it crossed. So yeah, they'll definitely do that. Yeah. And not just here, actually, other counties, they do that a lot as well too. But I mainly focus in Wayne County. Yeah. Cool. Yeah, absolutely.
Mentally, no, but health-wise, yes. Like now he's on dialysis.
Mhm.
And that does affect you, you know.
I was going to say that's a good argument. Anybody would challenge it would say.
Whenever there is a medical decision or anything like that, I always ask him.
Mhm.
But then ultimately,
Right.
I'm just gonna say that,
Yeah.
you know, because I don't want him. I want to do everything I can to possibly keep him here longer,
Mhm.
just because of our family. And I want him to see her success and.
Oh, yeah.
Everything, so.
The goal is to, one, make it so people don't need a full-blown guardianship, because so they'll start with lesser restrictive means, if you will. So like supportive decision-making arrangements and things like that. But once you do get somebody to the guardianship, you want them to keep that medication going on and that medical treatment because you want them to be able to become capacitated again, not just because it's the moral thing to do. We all deserve that autonomy, but it's just the best thing for society as well. The judge wants to be able to terminate that guardianship and say, go back to work, go drive a car again, go do normal daily activities again. Yeah. Yeah.
But, I mean, now financially, I just make all decisions
Mhm.
now because.
That's usually a little bit easier though, because you guys are probably, depending on how long you've been married, you're probably on the same accounts, joint account
Well,
holders.
actually, he has his own, his social security, like,
Okay.
his own account, and I had mine, and we had one together.
Yeah.
So,
And the power of attorney specifically probably says banking
Yeah.
and insurance and all those things in
Yeah,
there.
and that's only because he took care of it.
Mhm.
Like, this was a big blow, like, he paid all the bills and everything, my money was basically,
Yeah,
not that he didn't help, but,
sure.
So, yeah, well, I had to take over everything. It was
Right.
But now he doesn't make as much, because he's on social security, so it doesn't.
Yeah. So, and is he at like a extended care facility? He's okay. Yeah. So they're probably taking quite a bit of that as well. Really?
I have to pay them. I get a social security check, I have to pay them so much a month, like $500.
Oh, is that okay?
And then I keep it.
Well, that's pretty good then. So
Because we have-
don't let them know that.
We
Yeah.
have bills together. Which
Right.
is still home, she just graduated from the University of Mississippi,
Hmm.
so, that's what.
Oh, yeah. That area of law gets incredibly complicated, especially if he's either on Medicaid or gets put on Medicaid. There's specialists that I refer people out to when it comes to that, because that touches on a federal area as well, with your look back periods and just a nightmare of those things to go through. A paperwork nightmare, not really, not a real nightmare. So yeah, yeah. I think they already have the guardianship.
POA. No,
Oh, you-
it's just POA.
Oh, I'm sorry. Yeah, definitely. I misunderstood. I'm sorry. I thought you said that you were appointed the guardian.
No, but no, POA.
Yeah.
So I'm just POA.
Okay. Yeah.
financial-
Start the guardianship immediately. Not to pry too much. You were saying the health is declining. Do they have like an end date or anything to that, to where there would be an emergency to file into?
No, even like if he goes downhill.
Yeah. Right.
3 different times.
Okay.
And he's all the time.
I would probably, you can file for an emergency, a petition for an emergency guardianship on that situation. That qualifies. Just, none of us know what's going to happen in the future, of course, but that's not a good sign. So file for that so that you can be, at that time you can, absolutely. Yeah. Yes, it is. So nowhere near. Yeah, nowhere near. So a guardianship is a judge saying this person, so you used to look at person A, now person B has every single delegated power of person A. That's what that says. And a power of attorney is a document, it's a state document, but it only applies when somebody is still alive and capable to make the decisions that they're delegating those powers to. And they're numbered out. And it's granted, it's vast. I mean, it's funny, in some of mine, I still put that this person can conscript you to the army. So if we go back to like a civil war again or something, that good luck. I hope you pick the right person, because you're going to go fight. So, but it's just some of the statutory language that we put in there for that. That's only this person's wishes, but I don't get to decide anything for my own life as much as a judge could order other people to do for me. So the guardianship is heads and shoulders above when it comes to being powerful. Couldn't say anything because now she's arguing with the judge. Okay, have a problem with it, go talk to the judge. He would love to hear it. Talk to his bailiff first. She does not. He's an adult. Yeah, she has no. Right.
Even though they didn't get guardianship in time, she would be the next one to make this decision, right?
It would depend on the family structure. If there's other siblings as well, then it would be equal. Hers, yeah. Okay, yeah. So this falls into line, what we call the line of consanguinity, which is just basically a bloodline of things. And in intestate law, meaning somebody dying without a will, it sounds like he probably has a will, he has a POA though. The package is like the same price. So, yeah, it's all good. So I've heard it all, though. I'm never even shocked anymore. So I make assumptions and then I'm right, 55% of the time. That's it. So, but like not having the will, he would be considered intestate. But that only applies after he's he's passed.
Mhm.
While he's alive and kicking, give him the best shot. You two become the guardians. Just do that. Yeah. How old is the power of attorney though?
Me,
No, the actual document itself. When was it signed?
oh,
Oh, that's cool. Then if it was from like before you were born or something, that's a different story. Yeah.
I didn't get that.
Okay. Did you have any doctor that said his mental capabilities weren't compromised by the stroke? Because she could probably challenge that. Yeah. Okay.
Okay.
Well, I mean, there's an argument
Put them all up.
when you file for a guardianship as well, you have to put the next of kin type of people that you would expect, parents, siblings, children, those types of people. You have to put them on notice of the guardianship proceedings because they have a right to be heard at that guardianship hearing where the guardians can be appointed. And a judge can then hear from her and say, lady, you're crazy. He's a 50-year-old man that doesn't need his mom telling him what to do anymore. Yeah, he's been listening to his wife for long enough. He's going to do it again. Something like that is what the judge could say. So,
I love these torn books. You got me in one ear and her in the other ear, and
Yeah. It's a blessing for him that, he's still willing to listen to you. So, yeah.
I still want to do that. It was gonna change me.
Well, that's why it's kind of an appropriate topic for the family law thing, because like we were talking with parental philosophy when it comes to the children, they can be completely diabolically or diametrically different types of parental philosophies, but doesn't mean one's right or one's wrong, or there's maybe a shade to right and wrong to both of them. Yeah.
Thank you.
Oh yeah, for sure. Yeah. So, okay. Okay. Okay.
Questions for Joe?
No. Okay. Huh. It keeps doing that. I think it's easy. So thank you. Yeah. Thanks. So,
Thank you, everybody. for
thanks,
coming.
Aubrey.
Feel free to grab whatever you need.